City of Northglenn, Channel 8, keeping you informed of events in your community.
I'd like to call the City Council study session to order. Joanna, would you call the roll, please?
Mayor Downing.
Here.
Mayor Pro Tem Dodge.
Here.
Councilmember Schlesinger. Here. Councilmember Malika.
Here.
Councilmember Sowers. Here. Councilmember Joe Brown. Councilmember Becky Brown.
Here.
Councilmember Whitman. Here. And Councilmember Escobar will be absent.
Okay, thank you. The first thing on the agenda is construction defects. So, Corey?
Good evening, Mayor and Council. I will admit that you have absolutely nothing new in front of you for tonight's study session on this topic. So when we spoke about this last in January of this year, we went through some of what's in this packet in some significant detail, and I think the determination made at that time was to see what, if anything, the legislature was going to do and then bring it back. And here we are 6 months later, and the legislature did nothing. And also nothing has changed in any of the contexts regarding this issue in this sense. The Court of Appeals case that is being appealed to the Colorado Supreme Court is still pending. So there is no decision from the Colorado Supreme Court. There's no telling whether the legislature is going to do anything in the next session. So I think the risks, if you will, and the potential benefits for local construction defect reform are unchanged. There is still the risk, if the city decides to do something local, that it is adopting a local ordinance on something that could be preempted. The Construction Defect Action Reform Act, which is the current law in the state of Colorado, suggests that it is a matter of statewide concern, and that the remedy process for construction defect is what's in the act. Whether the city wants to consider something like a plat note, which many communities have done, which says that you have to use binding arbitration before going to litigation, or whether the City of Northglenn wants to take a more comprehensive approach and do something similar to what Denver did, which is put together an entire legislative scheme related to construction defect. They both have risk, because there's still the risk that this is a matter of statewide concern. And it's probably too soon to know what, if any, success these type of regulations have had. Again, some of this information is now 6 months old, but as of the beginning of this year, the media reports suggested that Lakewood had done this type of legislation, was the first, and still doesn't have an owner-occupied type of project. So I'm here to say that we're where we were 6 months ago, and the issue is still kind of on the table in terms of how you wish to proceed.
That's pretty interesting, really. Some discussion. Anybody? Yes, Carol.
Since the state can preempt the local authority, if we do it that way, is there nothing that would happen if you put it in your plat notes? Nobody can touch that?
There is still the possibility that the issue of preemption can be raised. But it's less risk, because it is one component, one very small component of a larger area, whereas the Denver model really goes through a lot of different components related to construction defect. The interesting thing about plat notes in my mind is not only are municipalities doing it, but you see in your materials counties, which are creatures of statute and have, less organic authority, if you will, are doing it as well. So I think that gives you more cover. My opinion hasn't changed that I think what's pending in the court system is going to be the best remedy, and that is that if you can have in your covenants certain rules regarding construction defect that can't be amended, which is what happened in the Court of Appeals case, that will have the best long-standing impact, because it won't be the government taking action, it will be the covenants that are recorded against the property by the builder that will ultimately have the impact of setting the rules for the kind of the mediation or the arbitration process that you have to go through. But we're still probably a year away, would be my guess, from a final decision by the courts. And the legislature can always weigh in after the courts weigh in. And that's one of the issues here, is this is uncertain. What we do know is that even if there is a legitimate defect, what often happens is that all of the subcontractors get dragged into the litigation. And so when you look at the cost to insure these types of projects, that's where it becomes cost prohibitive, because if you're, for example, the landscaper will typically get dragged in on a claim, even if there's not a landscaping claim. And even the cost to defend that, if there's no liability, is a cost that is subject to the insurance costs.
Okay, any other questions? Yes, Kim?
Karen, what does this have, or what, if you go with the plat notes, because that's the way I think that we should go with this one. What kind of effect does that have on existing PUDs? So, for example, the marketplace.
It would.
If we want something to happen at the marketplace, one of those things that we've talked about is getting some higher end multifamily in there. Can we still be able to get this wrapped in with that for somebody's condo construction over there, or even redevelopment along Huron, or even our areas?
A plat note would be triggered by new subdivision, so a new legal lot of record being created.
So things we have to do if we did.
Probably.
Okay.
Probably. The risk is if you have an existing subdivided lot and no change, you have no opportunity for the plat note.
That's what I was thinking, so thank you.
Anyone else?
I'm in favor of this. I just think that we need to figure out a way that homeowners can be protected, but at the same time encourage building of owner-occupied units that are potentially more affordable for our residents. I just think it's a good idea to have a diversity in our housing product that we're offering, condos, townhomes, whatnot. So, yeah, as long as we're ensuring that these homeowners will be protected and that they're not going to be taken advantage of, but at the same time, not allow the builders to be taken advantage of and held hostage for 50 years or whatever. I'm all in favor of this.
And I think the issue, and this is a policy issue more than a legal one, at the end of the day, is a plat note seeks to dictate the remedy. It doesn't suggest, or it's not intended to suggest, that there may not be a legitimate construction defect. But that's really where the heart of this is, that the construction defect law currently provides much more robust remedy, but I think there's concern that it's not being used correctly. So this is a mechanism that dictates at some level the remedy, but it doesn't. It's certainly not intended to prevent someone from having relief if they're the victim of construction defect.
Thank you.
Anyone else? It sounds to me like,
I think you've only heard from.
well, nobody else is really, yeah.
So you don't have a consensus.
I was about to go around and
Yeah, that's what I'm thinking.
and I'll ask it this way: is there anyone that has objection at this point for at least putting together a draft ordinance that has the plat note methodology?
Corey, I do have one question, and maybe I'm just not reading it right. It's something that I was not understanding. So on page 3 of the memo, at the top, it has it has a few bullet points. And I think that's all in regards to the court case, those bullet points, is that correct?
It is the portion of the plat note that was also subject to the court case.
So, okay, so now knowing that, then the second bullet note is confusing to me. Provision that the arbitration clause cannot be amended without meeting certain conditions. So you're going to put in an arbitration clause and then you can amend it and get rid of it? Is that what that's saying?
Yeah, just like any other subdivision, any other note on a subdivision, if typically it is the owner that is bound by the note, by a plat note, when they subdivide the property, and then when you buy into that, you see the note on the subdivision that says, you know, whatever the note may be. And so that provision can't be amended absent the landowner saying, I want to amend it, and the city, as the regulator, the land use regulator, approving that change. So that's exactly what it means.
Okay, so that's still part of the to be decided in that court case?
Yes.
Is that correct?
Because what's to be decided in the court case isn't on a plat note, but it's in the covenants. And so it's a different mechanism for getting the same recorded condition against the property. Instead of a plat note, which is the plat recorded against the property, it's in the CC&Rs, which are also recorded against the property, but the language, the restrictive language would be the same.
Okay, anything else? There you go. Okay, so you have direction?
I do.
All right, so you're still up. You're
Okay.
on the regulations.
Still makes me giggle like I was in high school, you know?
And the one thing, I kind of want to give a disclaimer, if you will, as we're going through the marijuana regulations in this sense, and that is that, and I think I said this the last time we had this conversation, certainly we can talk about the legal constraints related to how council wishes to regulate marijuana based on its local authority under state law. But at the end of the day, my recommendation is that it's going to be that you ask as many questions of Lisa and Joanna about this as you do of me, because they're the ones that on a day-to-day basis are administering the regulations that you adopt, are dealing with the licensees on a day-to-day basis, and I think probably have much better insights on a day-to-day basis than I do. And I'll use item number 1 as perhaps the best indication of that. And I think I've talked to some of you about the idea of whether or not you want to consider having a different type of marijuana licensing authority other than the council. And I've certainly talked about the idea of a hearing officer. There's other, you have in the materials in front of you that were, I think, passed out tonight, or not, are about to be passed out tonight. A survey of communities that regulate marijuana and how they do it. And you'll see that, well, some certainly have authorities, like Northglenn does, and some have city council acting as the authority. Others have hearing officers, some being municipal judge, some being a contracted attorney. In Boulder's case, the city manager is designated as the licensing authority and the hearing officer for violations. And then there's also, if you look at Wheat Ridge, there's a hearing officer only for violations and suspensions. So I point this out as an option for a couple of reasons. First of all, many, many years ago when the city created the liquor licensing authority, I think the city council at that time thought it was taking up a disproportionate amount of time and effort to do liquor licensing before it created the liquor licensing authority, and wanted to have a board of the city that had specialty in that area. I will be the first to admit that I think marijuana is far different than liquor. And so when you talk about having a specialty, if you were to look at a different type of authority, I would recommend probably a hearing officer, either a municipal judge or a contracted attorney, more than I would a separate authority, just because of the unique nature of marijuana and medical marijuana. But also there have been a number of issues with, we've talked, I think, extensively about the quasi-judicial component of this. You had the last licensee trying to reach out to the community, and I think the city clerk's office several times sending you what I thought were incredibly appropriate emails saying it is absolutely appropriate for them to be reaching out to the community, absolutely inappropriate for you to be there, since you're the quasi-judicial decision makers. But it does create a difficulty, not an insurmountable one, but certainly a difficulty. And then in my memo to you, you'll see that I pointed out that, and maybe I didn't point it out, maybe I was going to leave it to tonight, but based on the evidence that was presented at the hearing last on Grow House Northglenn, it would have been difficult, if not impossible, for me to have defended a denial. And I know there were certainly council members that voted against this, and that's not to say that you're not entitled to weigh that evidence in a way that you thought the needs and desires of the neighborhood were currently being met. But I would tell you I would have had a hard time defending that because we base it on the record. And the record in front of you was by a third-party hearing officer, or a third-party petitioning entity, and there really wasn't good contrary evidence. And so when you look at defending a decision, what you've heard me say gavel to gavel, from the time the public hearing starts to the time it ends, it would have been extremely difficult to have defended a denial. And that's not to suggest it couldn't be done, it's just to be perfectly honest and say it creates a lot of practical difficulties. You've had another case that's still pending in front of the Colorado Supreme Court on a liquor licensing issue. So this has been a litigious issue already. So I feel obligated to point that out as an option.
I have two things. Did you really just mean to say liquor, or did you mean to say
No,
marijuana?
marijuana. I'm sure I
Don't.
substitute them all the time.
So, again, I know what you're saying about the last meeting. I get that. But is the reason that would have been difficult for you to defend against because we don't have it tied enough into our schedule? Or is that just...
My personal opinion is no. I think actually you have tighter and better regulations than any other marijuana regulations I've seen, because most of the marijuana regulations in place deal with just what I'll call needs and desires. If the current establishments are satisfying need, you have the additional criteria related to impact on the community. That's unique in my mind. And so that creates the difficulty when you may, based on your role in the community, think you've hit the threshold. Yet the evidence you hear doesn't necessarily give you that on the record. The people that may show up or that you would expect to show up and come out against it don't. And in this case, where you send out postcards to a huge area, you have someone that goes out and does petitioning that is not paid for success, if you will. It would have been hard to defend the denial.
And do you think I didn't get one of those postcards because I'm Becky Brown with City Council? Or do you think that I didn't get it because I just didn't get it?
I don't know. I have no idea.
That was one of my questions. Did you?
I got them, yes.
I didn't
Actually,
get
I got both of them because they had two different things.
Oh, really?
Yeah.
Yeah, no, we didn't get anything, neither did the other neighbors across the street. So I just I didn't bring that up last week, or when we had that meeting,
Good to know.
but yeah.
Can I ask a clarifying question on
Yes.
that? Is that the postcard that was sent from the city clerk's office, or the postcard that the licensee sent about the community meeting?
The licensee said,
Okay, thank you.
yeah.
Okay, so you did get the notice from the clerk's office?
Yes.
Because that's the notice that's required under our code, and that's an important distinction.
Okay. I mean,
And I'm going to throw out one other just unique, that makes this unique as compared to liquor. To be a member of a liquor licensing authority, you cannot have what's known as, and the term under Colorado law is, an abhorrence to alcohol. So if you have an abhorrence to alcohol, you are not qualified to sit on the liquor licensing authority. And so it's part of the application process for the liquor licensing authority in Northglenn. There is no similar criteria in marijuana, which is, I think, what Councilmember Esquivel was struggling with. And I'm not sure there should be, but it creates an issue that I'm not comfortable with defending the city, because it is perfectly appropriate in my mind to have a bias or not be impartial for something that's illegal under federal law. Yet, it is clearly constitutional under state law. And so while I think, well, there's nothing about an abhorrence to marijuana in the law, it does create an issue where if you vote against it and there's evidence on the record that you may have a bias, I have a problem with you being an impartial decision maker. And so that is another reason why, when you look at this in total, I at least throw out the issue of a hearing officer.
I have a quick question. I'm kind of curious of why this is coming up now with the hearing officer, and I guess what brought this about? Did this come from the community? Did this come from business owners?
This came from me dodging and weaving and trying to defend the city council as decision maker. Certainly, Joanna and Lisa and I have talked about this issue because, for example, they're putting together a recommendation to you in their staff report. And their recommendation to you has been, at least in my view, very impartial. You know, if the evidence supports the finding that there's a need in the neighborhood, then vote in favor of it. If it doesn't, find against it. Yet, I think, and correct me if I'm wrong, with the evidence that they had and the indication that they had in the staff report, they may have felt more comfortable, and please step in if I'm incorrect, in actually recommending approval. But under the circumstances, didn't. Is that a fair statement?
Sure. I mean, I think those staff recommendations are going to change, and I think we discussed that. To really have a firm staff recommendation, because we have the facts of the application, we have the reports from the different departments, and I think it's only fair that we tell the authority, whether that's council, the board, or a hearing officer, what our staff recommendation is, since we're the ones who are compiling that information.
And that recommendation is always going to be subject to the evidence you hear at a public
Right.
hearing. There's no.
I was going to say, there's no way you can give a staff recommendation before it's supposed to be the information at a public hearing.
Right.
So I totally disagree with staff giving them recommendations saying, council, you should approve or disapprove. I think that what you've been doing has been great. I don't think, because personally, I think that it should be council. Marijuana is still too out there, being a divisive issue in our community, and one of those things where I think that we're the ones who should take the heat for it. And I don't think the staff should be put in the place to do that either. So I absolutely don't think the staff should be given this recommendation, because we're supposed to be doing it on public hearing.
And by analogy, when you look at liquor, what staff does, and staff's required to send something out to a liquor licensee about any essentially negative information short of what's going to be heard at the public hearing. So the idea would still be subject to what you hear at the public hearing. But in the past, we have certainly anticipated issues we knew were going to be at the public hearing. When you think of Botanicare and some of the issues that have arisen in that context, we could very well anticipate. If you look at, for example, this past hearing, we had the petitions. And so absent very compelling evidence about a lack of need, that was kind of the, if you will, the prima facie, or the evidence going in. It's not to suggest there couldn't be new evidence at the hearing that would be compelling, but it's based on what you have at that time.
I guess one of the issues that I'm having with how you're telling us that they presented it and somebody else didn't present the other side. So to me, what they presented wasn't enough evidence to say that it was necessary. But now it sounds like you're saying that we can't really use our own judgment on what is necessary, but that we need to have somebody else come in and give the opposite story to say, no, there's not any, and this is why. And I don't think that that's right. I don't think that's how we should have to be doing this. We should be able to use our own judgments. That's how the ordinance is written, and that we get to decide whether it's enough or not.
Based on the evidence, and that's the difference. And they're just, and the...
But now you're saying we have to have evidence from the other side saying that there isn't.
Correct. If there is evidence from the proponent saying there is, because it's a weighing of the evidence. And if you only have this evidence from one side and nothing from the other side, there is no evidence in the record to support a decision of denial.
So
And that
they come in and say, we had 5 people say yes, nobody said no, nobody's here to say no. It's in our community because we need it.
basically. I mean, when you look at the evidence in the record, that is correct. And that's the same with any quasi-judicial application. It is just more pronounced in this context.
The thing I have is, you know, at the end of the day, the buck stops with us. You know, and so I like I've said before, I take this very seriously, and I take the job very seriously, and I'm not sure if I'm ready to release those reins, because I'm out in my community and I answer to my community. And then what's going to happen, what I feel like is at risk of happening, is now I release the reins for somebody else to do that job, and I have to answer for their job. When the way it's set up now, I can answer for myself and I can explain what's going on. And so I'm not sure if I feel comfortable going to a hearing officer. And if that means I have to be here until 11 o'clock at night some nights, then that's what I signed up for. You know, and I know some other communities are going that way. I just don't feel comfortable with it.
Okay, Marcy?
And I agree. I'm not comfortable with the hearing officer, and I think part of that is I think collectively we all ask really great questions and that feed off of each other, and I think it's really important. And when I think about some of the cases that we've had, you know, going back to the Loslow, I mean, that is something that we sort of knew coming in, but once the hearing happens, I mean, there was so much that came out of that hearing, and I just don't know that I feel comfortable not being involved in that. And I think it also was part of, because it is so new, is part of a little bit of our learning curve in some ways, in coming back and revising, setting the moratorium, having the little round table that we had, and then revising that. I think that really came from us all being involved and participating. So I think it's still a little too new to release it, and I'm not sure I am interested in one person doing it. No matter how big of an expert they are, they just can't think of all of the questions. I just wouldn't be in favor of that.
Okay. And I feel like I'm obligated to at least give you the option. The one thing I would reinforce is, and it's the question that Councilmember Snetzinger, I think, is uncomfortable with, and that is that at the end of the day, a judge reviewing this has to find competent evidence to support your decision. And so you are stuck with the hearing record you get. And Northglenn's ordinance creates more opportunity than other communities for that evidence to come before you, because you have the mailing. You have the mailing in a large radius. So you give folks the opportunity to come forward and object, in addition to whatever process the applicant may go through in support of their application. But it can put you in a very difficult position.
Corey, can we get a copy of the notice, the mailing that goes out from the city? And then can we look at wording it, maybe I've never gotten one, so I don't really know what it says. But to tell people, if you disagree, show up at the meeting. I mean, because otherwise there's nobody out there, because we certainly can't go out to the community and say, hey, if you guys don't want this, come to the meeting, otherwise it's automatically going to go in. So if we don't have you there saying, no, you don't want it, then we have no record of any opposition, so you're stuck with it. You know, I mean, I just feel like we're really only giving one side the opportunity to present their side, whereas, sure, we tell residents, you can come and tell us we don't like it, but they don't. So
And the difficulty is it's not whether you like it or not. And that's, in this and in liquor, it is whether the needs are currently being met. And I think, and I don't remember who asked the question, but and it might have been you asked the question about what products you have, that's one way to show needs and desires. There are certainly others.
Well, and I think, Corey, since I've been on council, I've been satisfied with every decision regarding marijuana that council's made. And I feel like, we've been able to stand behind the decision that we made, and I think it's proven itself. I know that we're still in litigation on one, but I feel confident with that. And so there's nothing that I feel like that we've done as a council. Certain people have their opinions, and that's fine, but as a council as a whole, that has, warranted a change, because I don't think we've done anything wrong.
Becky?
First of all, I just want to get on the record that I have no bias towards marijuana shops or against, all right? That's not what that whole thing was about last week from my perspective, so I just want to make sure that that's out there out there for everyone to know. When I look at this list that you gave us, Corey, Thornton doesn't even have any, do they have any marijuana shops now?
No, it says under review, proposing an authority. So
Okay,
that's what they're proposing as part of the regulations.
Okay, and Wheat Ridge I know doesn't have any.
Wheat Ridge has medical, I
Medical.
believe.
Okay. I personally think it needs to stay within the city council for many of the same reasons that Marcy mentioned. It's so new. I do have a problem with the location of the last one, and that's where my problem was, not in what they were doing, all right? I live there. It's going to be a mess to get in and out. Washington was cut down to 1 lane last week, and it was a mess. That was my concern, and the safety of the residents. But I think I have more questions than you may even have the time for, but I really think it should stay with city council. I don't think it needs to go to a board. We don't have that many, and we don't have that many questions or license renewals coming up. What I would like to see is that I'd like to know if our city inspections we do city inspections on all of the shops in our city, right? I would like to know if they're up to date. That much I would like to know, so I don't know who can provide me that information. And some of the findings from it. Okay? But I really want to know if we're up to date and we're doing our part from our end to make sure that we're regulating these things.
Well, when you say inspections, what are you, actually the definition of inspections at this point?
Well, there is and probably help me, there is a DEA component of it, right? Where they come in and they're inspecting seed to sale and stuff like that? Okay.
That's the med. So the state, we don't necessarily know when the med comes in and does its inspections, but certainly the city does inspections as well. And I don't know if you want to talk to that at this point, but there's certainly.
Well, I would want to ask a clarifying question whether we're talking about routine annual inspections that we do as part of the license renewal applications or compliance checks. Those to me are two different things.
I'm really interested in compliance checks.
Okay.
I'm really interested in,
At this point, they're working on.
To the best of my knowledge, the city has not done any
Right.
compliance checks of its marijuana businesses.
okay,
They're still
so,
working on that.
so we're doing, what was the other one you said, Joanna? Just the yearly?
Routine inspections with the renewal applications
Just with the renewal application?
and new applications.
And I think this goes back to the police department is looking at this also, so I think
Okay.
there's different pieces that have to be put together to get this taken care of.
What pieces are those? Because
That would be more officers,
Yes.
that would be more budget, money, a lot of different things that right now we don't have.
is that coming to us in this next budget session, or?
It will be, from what I understand.
Well, the staff plan that we haven't been doing that all along.
No, they haven't been. Go ahead. No, I'm sorry. This is a study session for the council, so. But the police chief, I know, has been working on something to bring to the council.
And I know that some of it can be a staffing issue, and I do understand those things, but I think we have to make our end of the compliance up to date.
Right.
And the chiefs, you know, have some very valid concerns.
And this whole process started when Councilwoman Snetzinger brought that up several months ago. And from that point on, they have been working on this, but it's really going to be something that's going to impact the budget for the police department. And so that's why they're making a presentation. They will be making a presentation.
Can I clarify, is it an actual presentation or it's just a budget request? Because I
Oh,
kind of
it
feel
has to be a-
disappointed that it hasn't happened yet.
Right,
We know
and it
about
needs to be a presentation as well as in.
But I'm just
Yeah,
making
yeah.
sure that that's what we're getting, not just a
Right.
budget request.
Right.
I think we're meeting at a retreat, and I think Jim is prepared to supply all of his staffing analysis and details to council to include compliance checks for medical and retail marijuana.
Joanna's.
Well, I do just have a couple things to add. I mean, compliance checks have always been important to our office. And just to go back to the inspection piece of that, most of these businesses have a dual license. So we have a medical license and a retail license that unfortunately expire at different times during the year. But that actually, on the flip side, is a positive thing because that allows us to do the routine inspection twice a year. So the police department they are doing those annual inspections once, if not twice, per year on the businesses. And then to add on to the compliance piece of that, I know it may be a staffing issue with other departments, but I've also suggested, although we haven't had much of a discussion about it, that if it just needs to get done, we'd be willing to put in a package request for the budget to outsource that piece of it. There are companies who provide business audits and compliance checks for regulated businesses like liquor and marijuana. And if compliance is the goal to me, I think at least outsourcing that part of it would be a good start. It's just one more option.
I would just, for that, just specifically to that comment, that would take a lot more than just, you know, we'd have to look at some cost and see if it can, you know, it may be less expensive to outsource rather than bring on an FTE.
Oh, definitely less expensive.
Less expensive.
I think we need to look at every avenue.
I just wanted on record that we need to get that.
And our fees can cover those operational costs as well. So if it's a third-party outsource, sort of similar to what we do for the building department, I mean, to me, it's not that great of a cost at all.
The chief has a comment.
Yeah, and I understand Joanna's concern on the compliance when it comes to, you know, staffing and trying to get these things done. And this has been an ongoing issue, and when it rises to other things that we've been involved in as a police department, it's been difficult. My concern with outsourcing is twofold. One, there's a lot of things that are tied to it that we know that's happening in certain, there's certain busts that we just had that, you know, in the community where we had pounds and pounds of marijuana that was illegal that were tying back to dispensaries. The other thing too is in those compliance checks, if we find a violation, we can issue a summons right then instead of coming back later after the intel we get from, you know, a third-party company. So there are my things, and I can tell you on the compliance checks when it comes to marijuana, liquor, we have our sex offender list. These are some of those things that we know we need to get that going. Right now, the inspections are done by a commander because he's the only one that can do it because everybody else is so tied up in the calls. So that's where my, you know, we're trying to put this stuff together. And I can tell you, it's not just this last year. I've had, you know, I've been trying to get staff up in the police department for many years, and managers would deny those packages before they got to you. So this next meeting, when I get to go through and talk about the staffing request and show you guys, I mean, it's in black and white. David, when he was the manager, said, Jim, show me the evidence of it. So I'll show it to you, and it's almost shocking, you know, on the staffing that's required in the police department. So I hear that stuff. We will get to it, and I can tell you our priorities when it comes down to it, that wasn't as big as what we were handling day to day. You know the year we had last year.
I know.
Or the year we had, so.
And I guess I want to just point out one thing. There are different types of what I'll call compliance inspections, because there are certainly the kind that involve inspecting the premise and inspecting the inventory. There's also inspecting the books. And so, this may not be all or nothing. Because certainly inspecting the books, there are a whole host of what I understand to be former marijuana licensing officials that are doing some of this work on the paperwork side. And that can be part of the compliance inspections as well, whether done in-house or whether done by a third party. So inspection and compliance checks are very broad, and it may not be one or the other. It may be a combination of both.
Marcy, did you have?
And I don't mean to sound like I'm coming down really hard, but we kind of act like we've only had marijuana for a year or two. And so this is like a whole staff thing. It's not new, we've had it. And I think, at least from my perspective, I was quite surprised that we weren't doing it. And I've expressed to the new city manager, that I want to see all of the budget requests that are being denied and the reasonings why, because then council seems like we don't know what's going on, and so we didn't know that you were asking. But I guess I just want to keep reiterating that this isn't new to us. Like, we expected that it was being done, and I certainly thought that it was, and so it was a bit of a surprise that it wasn't. And I realize that we're working towards it, but I gotta say, like, regardless of whether or not it gets approved, it's not okay to me that it doesn't get done. And I realize that there's priorities, but from our perspective, like, we gotta do our job in being compliant and watching it. And if it's a staffing issue, then it's gotta be an outsourced, and we just have to deal with it. Like, if it's denied or whatever, it has to get done. It's like not okay for me to come back next year and hear that we haven't done any, whatever the decision is. It's just frustrating to me that it continues to go on, and we've had it for years.
Okay, Carol.
I just want to give my buy-in on us as the licensing authority. I am in total agreement with everyone so far that we should remain. For me, it's the community buy-in part of it, same as everybody else has said, that a hearing officer wouldn't have. But I am curious, when you do have a hearing officer, is it a paid position, and how are they chosen? How do you pick one?
Well, some communities use the municipal judge, and some communities do essentially an RFP or an RFQ, and people apply for it. And it's typically attorneys that do this type of work. So, Fort Collins hearing officer, I know, responded to an RFQ, and she was the prevailing person, and has been doing them since.
I was just curious, but I think we should stay.
Jordan?
Yeah, I'm in agreement with everyone else about us being a licensing authority. It's really hard to give that up and then not know what questions are asked or what type of questions we can come together and ask, and essentially develop a relationship with these people as well and in our community. So when we have to answer to members of the community why we decided this is the questions they have that we're able to answer, as opposed to just reading a memo or something on it.
Okay. And I'm in agreement with everyone.
Yeah.
I really think the council needs to still retain that authority. And I do want to emphasize that we really do need to hear that presentation in full, as well. So maybe it's a presentation as well before we have the budget hearing. I don't know, I don't know how this is set up as far as, what the city manager is doing.
Yeah, I don't really have a lot to add to that, Mayor, other than I've personally worked with Jim and all of his commanders and staff on basically a very comprehensive staff plan, not just compliance checks. And, the whole police services falls into what level of service they can apply to the field with basically the revenue stream we have coming in. So there'll be some tough decisions coming up in the budget planning process about potential staffing up or outsourcing, and how we afford to do all of those things. So he has a full presentation, not only on compliance checks for marijuana, but all the other police services as well. And I think it's a good presentation.
Okay, great. Okay. Yes.
I don't know if Corey or Joanna can go over some of the other issues that are in this memo, but there's 6 or 7.
Yeah, I've only just begun.
Okay. 'Cause I thought it sounded like, okay. I was like,
No. And in fact, I want to go back.
Okay, I was like, there's a lot.
Oh, no, okay. This was just item number 1. And also going back to Councilmember Snetzinger's question about the notice, the language of the notice, and this is for retail, 1816-7F2, and I'll email this to everyone as well, but the language is, in the notice, is this application will be under review by the Marijuana Licensing Authority for the City of Northglenn. As part of the review process, the authority will consider the number, type, and availability of retail marijuana establishments in or near the premises under consideration. Comments regarding this application may be sent to, and then it gives the address. Additionally, public comments on the application may be presented at the public hearing to be held on, and it gives the date, time, and location. So that's the notice everyone in the neighborhood receives.
I'd still actually look at it
Okay. Yeah, no, we'll send it to you.
and just beef that up so that people understand that they don't want any qualified comments.
Okay.
I think it's, I agree with Kim, but we also have to be careful that we don't enter a bias one way or another.
Right.
Yeah,
That's
so-
exactly the line we have to draw.
Yeah, yeah. Okay, if this conversation is done, we'll go probably to number 2.
Yes. Second one, which I hope to be a little easier. You have some marijuana licensing fees that are currently in one of the handouts that was given to you that is either set by resolution or set by the code, or for which there is not currently a fee. And so I think our recommendation would be certainly to allow them all to be set by resolution. So each time a fee is set, it doesn't require a code amendment. And then to look at a local fee for those for which there's currently not a fee.
Okay, I agree. Any? Okay,
Can we, so resolution, so there's certain things on here that there's no fee, which I find kind of interesting, that a change in financial ownership of 10% or less, there's a fee, but more than 10% there's not a fee, which I would imagine might entail a little more work if there's a more than 10% change.
And that's typically
So-
going to be a transfer. I mean, that's how it's been, but that's one of the reasons that we would recommend actually putting those in place, having the fees in one resolution. The code would simply say fees to be set by resolution, so it would give you the flexibility to address those as needs require it.
okay. Anyone else? All right, number 3.
Number 3 is change of location. And when Northglenn adopted its marijuana regulations and then amended its marijuana regulations, as we talked about then, both times, this is in many ways geared by what's in state law. And when you think of, I'm going to use liquor as the analogy because marijuana and liquor are intended anyway, it's at the state level to be largely analogous. If you think of a liquor license, you think of needs and desires of the neighborhood, and you think of the applicant and qualifications of the applicant. It is essentially the same thing with marijuana. So once those are the criteria for a new application in a very large sense, then if the owner changes, it's a transfer of ownership. You don't revisit the needs and desires of the neighborhood. You only look at the applicant to see if the applicant is qualified under state law, liquor and marijuana. Similarly, for liquor, it is very explicit that when there is a change of location, you don't revisit the applicant, same owner. So the owner didn't suddenly become unqualified. But you look at the new location and whether something has changed in the location as it relates to the needs and desires of the neighborhood. Currently, Northglenn doesn't have a good code provision on change of location. If there were to be a change of location, we would recommend you create a process, but until that process is in place, the purpose tonight is to suggest there should be an ordinance revision that does the same thing.
I'm gonna,
Go ahead, whoever.
I'm gonna agree with that just because, well, because if I'm listening to you correctly, you have a license, and if you don't come before us, you could move outside of our chosen area of where we would allow a license to be?
You can never move into a location that's prohibited under the locational requirements. But the locational requirements only get you in the door for purposes of application. The city can't accept an application if you don't meet the distance requirements. So that's the first question is, does it meet the distance requirements?
But I'm just moving.
Still, you still have to be in one of the areas, and there is a marijuana business location criteria map. You have to be in one of the areas that is unconstrained. Even if you have an existing license that you want to move, you would have to move it to an area that is qualified. But then, that only gets you in the door. And the idea is, even if you're in the door as being locationally authorized, you still have to show that the needs and desires of the neighborhood aren't currently being met and there aren't negative impacts on the community. And so that's the suggestion.
So you're breaking up this by neighborhoods when I feel like we've been looking at it as a city as a whole. When it's brought before us.
And so
Right.
that's the second part of this bullet point, is currently the city is effectively the neighborhood, because you're looking at whether the needs and desires or the existing outlets in the city are currently meeting the need. Okay? That is, and then the negative impact piece. The location, if nothing else, under the current criteria, you have to show that there's no negative impact caused by the marijuana business at that location. But that leads to the second question, and that is when you think of liquor, liquor has roughly, depending on the community, a radius that is the neighborhood. It's not the whole city. And the question is whether you want something like that for marijuana or whether you want to continue for it to be the entire city. Because marijuana is different, there's no question, because there are other communities, some neighboring communities that don't allow it. Whereas with liquor, the neighboring communities allow it. So it is easier to, I guess, justify, if you will, that the neighborhood is smaller. And in fact, Colorado law for liquor in general for bigger communities requires the neighborhood to be smaller. Again, there's no similar law yet for marijuana. But the question is whether it is needs and desires of the entire city, which is what it currently is, or whether you want to constrain it further to, for example, and I put this in the memo as an option, the radius where the notice is sent out. Is that your neighborhood for purposes of needs and desires currently being met or not?
Does this include also like extending a current location, as we saw at Botanicare, where they bought?
No, that's a modification. That was a modification of premise.
Because it's still, okay, all right.
So I'm definitely, I understand that you wouldn't want to revisit the applicant. I definitely would want to revisit the neighborhood. So however we have to go about that, I'm on board, because that neighborhood should have the same right to come in and say how they feel, if they feel. So however we do it, that's where I'm coming from. I think the new neighborhood should definitely have a say.
I would certainly recommend that.
Right.
Yeah.
And then I guess the second question, which is currently your ordinance says needs and desires of the existing outlets effectively in the city. It does not constrain it to the area that is what I'll call the impact area, where the notices are sent out. Do you want it to continue to be citywide, or do you want it to be that half-mile radius as the impacted neighborhood for purposes of needs and desires? The difference in the evidence, and I'm going to speculate entirely. This is a hypothetical, but you may have, for example, an area. Let's say it was Natural Selections redoing it, where you'd say there's nothing, or there's less businesses on 104th as you're coming into Northglenn, and that is a need that is not currently being met. It may not be product, it may be geographic. Similarly with Grow House Northglenn, talk about that part of town, if you will, and not having businesses in that part of town. Whereas if you're talking about citywide, it's going to be a little more nuanced. It may be product. It may be what you do differently than another business. There's no right or wrong answer. It is more difficult when you do it citywide. That doesn't make it wrong, because again, marijuana is different than liquor. It just is. But it is more difficult because using the last application as an example. The questions about products were absolutely appropriate under Northglenn's current ordinance provisions. But it's a much more nuanced analysis.
So if we're supposed to be looking at it citywide, why do we have such a small radius of when the notices go?
Because there's, the way Northglenn's ordinance is created, there's, instead of neighborhood and qualifications, there's a third criteria, and that is impact on the neighborhood. So it's, even if the needs and desires are being met, if a marijuana business is going to create more negative impact on an area than, say, a dry cleaner, based on traffic, based on the other things in the ordinance, then that is a criteria you can rely on. The difficulty with the last application was that the evidence was that it would have been a difficult location, whether it was marijuana or fast food or any other retail use. It was the location that was a problem, not the type of business and whether the type of business added to the problem. That was the evidence. And that's why I said it was difficult from my perspective for purposes of how our criteria are laid out.
Okay. Kyle, did you have something?
I'm in favor of notifying the new community if we're going to have a change. The question I have is, I know that you said that there's no communication with the community when there's a change of ownership, and I would like to know why that is, because I feel like the community should have a say on who's coming in to, run this establishment as well. And some people might think that's micromanaging, but with something like marijuana, I think it's important that we have ethical people running these dispensaries, and so why doesn't the community get notified of that and have a say in that?
Because qualifications under state law and under your code are not whether you like someone or not.
It's not liking it, it's ethical and making sure that this person that's coming in is going to be an appropriate fit for our community.
Fit is not, and then that's part of the issue, is there has to be an objective nature to it. Under both liquor and under marijuana, there are qualifications that an applicant has to meet. You look at their background, you look at their criminal history, you look at their age, there's a whole host of things in your ordinance. It's the types of things that under state law, in both, again, liquor and marijuana, the community's not going to know. They're not going to know whether someone was less than truthful on their application.
So I'm confused, because isn't that like a big part of our Laszlo situation? I mean, that, but didn't you just say we can't use that criteria?
No, you do. But the point is, do the people in the community, in that half-mile radius, what are they going to know about that? You got all that information from the business dispute, and from the application process and the fact that there were issues with their application.
Okay.
So it still doesn't answer my question, why the community's still not notified of that process that's going on, so that they can maybe show up to the hearing. I mean, it's troublesome to me that there's no communication whatsoever for that process, because I think that there's information that can be learned from that hearing and they can have their voices be heard. I think that it still doesn't make sense, and I know what you're saying, that it's a touchy subject, but
If you would like notice of a transfer, we can certainly do that. I'd recommend against it because I think it creates an opportunity for evidence that is not going to be relevant to the transfer determination. That's the issue I've got.
So I don't mean to take up time, guys, but so hypothetically, if somebody comes in and there's some questionable character issues potentially that's brought up at the meeting, and a resident comes up and says, what I've heard tonight, I don't want this person in our community based off of what I've heard tonight, that's not appropriate, that we can't consider that?
Correct. You would get to decide that without their opinion, because the question is, did they lie on their application, for example? Were they in it? Did they have some deceptive business practice? And the fact that the public weighs in on whether that is good or bad isn't relevant to whether or not they've met the criteria or the qualifications as an applicant.
how does liquor handling?
Same way.
Same way? That,
Yeah.
yeah, I mean, we can't treat one, you know, than the other in that respect, because we don't know when someone's, you know, spot at a small business.
And typically, and I know this is oversimplifying it, but typically it's rarely the issue that is brought up that makes someone disqualified, it's the cover-up. Because there will often be a question about what's this on your history? And there may be a perfectly honest and innocent explanation. You rarely get that explanation. And it's often that is the basis. And that's why the language about character and reputation is in there, because it is often the untruthfulness under oath when you're asked questions about your past more than it is your past.
Do we put a sign up, a public notice sign that at the location about change, if there's a change of ownership? So no notices, no public notices, nothing in the paper, nothing, they just show up.
So what
And in fact, there, under liquor, there's, and I need to check, but there's not normally a hearing. The hearing is only necessary if there is an issue.
So what I was thinking is that if a resident somehow knew this new person and had true evidence of wrongdoing or something else that would go to character and presented that in the public hearing, that would certainly be something that we could use
Yes.
in our decision. But other than that, to me, it seems like residents it would be more hearsay type
Correct.
issues at public hearing with a resident saying, gee, I don't like that person because they live next door and they didn't keep it on them. Or, you know, something like that where it was the true dislike of somebody rather than their true moral character and issues from issues or any of those types of things.
And so here are the person's, well, why don't you go ahead and then I'll talk about who's.
I was just going to note that if council causes a hearing to be held on an application, then we do notice.
Yes.
So there would be notice at that point.
So right now, if there's a change of ownership, they have to come to us, so there is a public.
Not a public hearing.
Oh, but they just, okay, I got you. I see the distinction.
And so here are the persons that are prohibited as licensees.
Right, yeah.
Anyone who hasn't paid the fees. Person who is not of good moral character. Corporation whose officers, directors, or shareholders are not of good moral character. Sheriff, deputy sheriff, police officer, prosecuting officer. So chief can't be a holder of a marijuana application. Anybody under 21 years of age. Person that can't be a retail food establishment or a wholesale food registrant. Person who has not been a resident for at least 2 years. Person who has discharged a sentence for a felony within the past 5 years. A person who at any time has been convicted of a felony for drugs. And that's basically the criteria. So, and then false statements. So it's the types of things that are uniquely going to be found in the background investigation and how they respond to your questions.
Okay. Anyone else? Well, I think we should leave it the way it is at this point. Yeah, just-
Except for the change of
Except-
location.
Yeah, but I'm just talking about the conversation we're just having, so, all right. I
Does-
understand.
We're going to resend a notice if they want to move to.
Yes.
Okay.
And have a hearing on a change of location.
Right.
That would be the language.
Thank you. Okay. All right. Next.
Background checks.
Can I just clarify, so what about the neighborhood? Are we leaving it citywide, or are we going to designate a
Thank
neighborhood for each application?
I'm okay with the neighborhood.
All right.
I mean, I don't know how to answer.
You mean for a change of location?
Or a new application. It would be the same. It would be the same analysis for both.
Yeah, see, I'm thinking with
I
change
think
of
leave it
location.
as the city.
Yeah, that's what I thought I heard.
To me, what we've been doing, we've really been looking at it at the neighborhood anyways. Because we only do, G, was only that neighborhood notified. So for me, it's been more about what's going on in that neighborhood rather than what's going on in the entire city.
Yeah.
So to me, I don't think it's broken.
No,
I
don't either.
misunderstood that, so
Yeah.
yes, I would agree,
Okay.
leave it alone,
Yeah.
yeah.
Okay.
Background checks. From discussions with Joanna and Lisa, I would suggest that the background piece is handled more than adequately by the state's process of becoming a key employee. And what the city has been doing as a practical matter has been relying on what the medical or the marijuana enforcement division does anyway. So we would recommend that be clarified, that we can rely on the meds investigation and background investigation of key employees as part of our background investigation. Is that?
And support employees.
Right.
as
And
well.
support.
Yeah, so all employees. We would, we're not recommending that we don't verify that all employees have obtained what they call an occupational license with the state med. We want to verify it through the state since they conduct such a thorough investigation when any of those employees apply to the state for that license. And so it's really a duplicate process if the city did it. And if we were to investigate each and every employee, as it states in the code, it would definitely require more staff resources. The licenses that are issued through the state are good for 2 years for each employee, and whenever an application is submitted, we do ask for documentation. You'll also hear us refer to it as a badge, the state badge, and that's sort of the same thing as that occupational license. So we do confirm that each and every employee at that business has obtained that state badge or license.
They do, MED does a very good background check. I